Thank you very much. I now call on Ruth Maguire on behalf of the Equalities and Human Rights Committee.
Thank you, Presiding Officer. I'm pleased to speak in this debate on behalf of the Equalities and Human Rights Committee. It's 30 years since the UK ratified the UN Convention on the Rights of the Child, which under international law sets out the civil, political, economic, social and cultural rights that all children are entitled to. And I agree with the Deputy First Minister that progressing this legislation is a moment of joy in what are very difficult times for everyone. Incorporating the most widely ratified human rights treaty in the world into Scots law is a landmark moment for Scotland. A new bill which legally obliges public authorities, including Scottish ministers, to respect children and young people's rights, placing them under a duty to not act incompatibly with the UN Convention. The bill will allow children and their representatives to take public bodies to court for breaches of their rights. This bill has been the focus of committee's work over the latter part of last year. We welcome the Scottish Government's maximalist approach that seeks to go to the very boundary of legislative competence to ensure children and young people's rights are respected, protected, and can be fulfilled to their fullest extent in Scotland. In keeping with this maximalist approach, the committee considered it vital that children have their rights protected, respected and fulfilled as a matter of urgency. That's why we urged the Scottish Government to amend commencement provision to ensure this legislation comes into effect 6 months after the bill receives royal assent. I appreciate the Deputy First Minister's assurance that serious consideration is being given to this important matter. To inform our scrutiny of the bill, the committee issued a call for evidence on the 7th of September 2020, which closed on the 16th of October 2020. We received 153 written submissions on the bill, largely from organisations in the public and third sector. Children and young people are at the heart of this bill. That's why the committee held a dedicated call for views for children and young people. Crucial to its success was the Associated Facilitators Pack, developed with the assistance of Together Scotland, the Children's Parliament and Children in Scotland. It's evidence of their effort and skill that the committee received more than 50 responses from children and young people as individuals, from primary schools, high schools, modern apprentices and other children's organisations. We thank everyone for sharing their knowledge and time. Creativity and innovation didn't stop there. Responses included reflective writing and drawings, as well as stop-motion videos. And I would invite members to have a look at the ideas there. As you know, children are not a homogenous group. With the assistance of many voluntary groups like Scottish Children and Young People's Centre for Justice and Aberlour Guardianship, we listened and spoke to children under 12 years, young people between the ages of 12 to 18, young carers, young refugees and asylum seekers, young minority ethnic people, children and young people with additional support needs, care experienced children and young people, LGBT young people, and young people with experience of the youth justice system. Through these varied activities, we came to a real understanding of what they hoped the bill would achieve for them. At the Children's Parliament session, young participants said adults sometimes do the wrong thing because they don't understand children's rights. An example given was, and I quote, "If a child doesn't know how to tie their shoelaces, then people teach them. If a child doesn't know how to behave, then people punish them. That makes no sense." Young refugees told us about the importance of Article 22 of the UNCRC, that they have the same rights as children born in that country. They told us this meant they could dream of a future, could receive an education and health services like people living in Scotland. If they didn't have these rights, they said they would feel isolated. Our child-friendly version of the Stage 1 report, published simultaneously with the requisite Stage 1 report, ensured children and young people have a report that speaks to them, about their interests and shows how their views were listened to and taken account of in the committee's considerations, and what happens next to the bill. If any of the young people or children that helped us are watching, I would just like to place on record and say to them directly again, thank you very much for your valuable insights and all your help. Almost everyone who shared their views with us through submissions, oral evidence or participation, whether academics or children, had one thing in common: and overwhelming support for the bill. This piece of legislation has the potential to put children's rights at the very centre of public authority decision-making. However, we believe, as the evidence to the committee has shown, there are areas where the bill can be improved. For example, we called for the definition of public authorities to be widened to ensure organisations such as private schools, housing, residential care and childcare providers are not excluded from the legal obligations in the UNCRC. This is because experience with the Human Rights Act 1998 has shown that courts have defined the term narrowly, exempting private or voluntary bodies when carrying out public functions. The committee believes this must not be the case under this bill, and so we recommended that the Scottish Government consults main stakeholders to investigate how the definition of a so-called hybrid public authority could be tightened to avoid similar issues arising. And we welcome the Scottish Government's commitment to bring forward an amendment to strengthen protection in this area. Under the bill, as well as the Children's Commissioner having the ability to take cases, children and representatives acting on their behalf will be able to challenge public authorities in court for infringing their rights. The new legislation would allow the courts to strike down legislation that's incompatible with any UNCRC requirements. However, submissions to the committee raised concerns about the accessibility of the existing courts and tribunals service to children. Our report called on Scotland's top judge to reflect on this evidence and to provide an update on progress being made towards developing a child-friendly court system in preparation for the new legislation. We look forward to receiving this progress update to inform amendments, inform the amending stages of the bill. We made further recommendations aimed at improving access to justice for children and young people. For example, in relation to ensuring judicial remedies for infringements of children's rights are effective in practice. Rosemary Agnew, the Scottish Public Services Ombudsman, considered it important that remedies should drive organisational change and, vitally, should consider what children might want as a remedy. We're pleased the Scottish Government has agreed to amend the bill to require courts and tribunals to ask for the child's views on what would constitute an effective remedy. The committee, however, asked Scottish ministers to reconsider its position in altering the definition of remedy so it is just, effective and appropriate. One of the key operational mechanisms of the bill is the requirement on Scottish ministers to make a children's rights scheme to set out how they will comply with the duties in the UN Convention. Many stakeholders argued that the scheme could be strengthened to include measures to support children with protected characteristics and vulnerable groups. Juliet Harris from Together Scotland referred us to our consultation events as they showed that particular children struggle to access their rights, such as children whose first language is not English, those who might face food poverty or those who cannot go to school. Una Brown from the Scottish Commission for Learning Disability called on the scheme to refer to the UN Convention on the Rights of Persons with Disabilities, so young people with learning disabilities, alongside those with other protected characteristics, see themselves in the bill. Otherwise, it might not be seen as being helpful to them in realising their human rights. Further inclusions were called for: access to advocacy support, legal aid, human rights education, and a child-friendly complaints mechanism, each one fundamental to ensuring children's rights are made real in practice. We welcome the Scottish Government's intention to strengthen the scheme by requiring ministers to include arrangements in respect of child-friendly complaints mechanisms and ensuring effective access to justice for children and young people. It would be helpful if the Deputy First Minister could clarify whether these amendments would address concerns around protected characteristics and vulnerable groups. In conclusion, Presiding Officer, I'll finish with a quote from a young engagement participant from the Carers Trust Scotland who said, "The UNCRC needs to be out there and be known. Unless it's known about, it's just there. We need a public conversation about UNCRC and young people in Scotland." This highlights the critical importance implementation plays in the bill's success. Let's not just have the bill there or think that now the UNCRC is incorporated. That's all we need to do. We need to make sure the bill works to advance the culture change we all want to see for our children and young people now and for future generations. Presiding Officer, the Equalities and Human Rights Committee supports the general principles of the United Nations Convention on the Rights of the Child, Incorporation Scotland Bill.